Okay, sir. We are live now in YouTube. So Pragati, you may continue with your speech.
Just give me one
Good
moment. Sorry,
afternoon,
just give
sir.
me a moment. Huh?
Okay, sir. No issue.
Okay, sir.
Yeah, sorry.
Yes, sir. So we are going live now in YouTube.
All
So
right.
we can start our session. So yeah,
Yeah.
Pragati, you can continue.
A very good afternoon to all our viewers. Today, we are honored to be graced by the presence of the Honorable guest speaker for today's event, Mr. Santosh Pal, Senior Advocate, Supreme Court of India. Before being designated as a senior advocate, he has served as an advocate on record in the Supreme Court for a long period of time. Sir's father, Mr. M.J. Paul, is also an advocate on record in Supreme Court. Sir has authored several books like Appointing Our Judges, Forging Independence and Accountability, Choosing Hammurabi Debates and Judicial Appointments, and The Maoist Movements in India, Perspectives and Counter Perspectives. He has appeared in several landmark cases before the Apex Court, including the famous Fourth Judges case, that is, Supreme Court Advocate on Record Association versus Union of India, which struck down the 99th Amendment of the Constitution, which judgment was rendered in the year 2015. We are confident that with such mammoth experience, Sir will be enlightening us in the next couple of hours. Now, I would call upon Mr. Jyoti Prakash Dutt, co-founder Team Lex Cognoscenti, to take forward the event.
Thank you, Pragati, for the introduction. Though our sir doesn't need any introduction, but still you have introduced very well. Good afternoon, sir, and good afternoon to all the participants. I welcome you all on behalf of my team. I am Jyoti Prakash Datta, co-founder, Team Lex Cognoscenti. I welcome you to the fifth edition of Lex Cognoscenti's national webinar series. We were graced by several other dignitaries in our last editions, and this edition is going to be very special because we are graced by the presence of an eminent advocate who has a lot of experience, and he has also authored several books on the particular theme that we are having today. So, despite and apart from that, he has a lot of experience before the Honorable Supreme Court of India, which is going to be very enlightening for us. So, before I hand over the mic to our Honorable Sir, I would like to introduce you all to the theme of our today's event. The theme will revolve around three sub themes. First would be the Collegium system of appointment. As we know that the Collegium system of appointment has gone into controversy for certain appointments, and the second sub theme will be about the National Court of Appeal. And there are several sections of the society who are always trying to establish National Court of Appeal, and they have appealed to the Honorable Supreme Court as well as Law Commission and the government to establish National Court of Appeal. Apart from that, there are also several demands for national All India Judicial Service, and that is a long due, which has not been done yet. So I am not going to describe all these things because we have an expert with us. So without losing any more time, I would request Honorable Sir to take over the session and enlighten us with his knowledge and intellect. Please, sir.
Yeah, good afternoon, everybody. Thank you for inviting me for this talk. I'm glad that students are very keen on knowing about the appointment of the judiciary and its intricacies, its problems, and its various dimensions. I mean, at least when we were students, this was probably last on our minds. But I'm glad that I find more and more universities are actually, there is a whole body of students who are very keen to know how this system is working and how it can be rectified, how it can be remedied, etc. Now I'll tell you some the nature of this whole uh, issue of judicial appointments as to what is the issues involved, how its history has developed, and where we are today. See, the if you look at the articles 124 and 217 of the Constitution, there is a little vagueness about how what will be, who will determine as to who will become a judge of the higher judiciary, namely the high courts and of the Supreme Court. Now, there are three wings to the government, as you all know. There is the executive wing, there is the judicial wing, and there is the legislature. Now, who has the primacy? Now, this has a little history to the whole problem. See, when we attained independence, one of the primary concerns at that point of time was land distribution. There was a major problem of inequality of land distribution. It was necessary to bring in land reforms. And the first of the land reforms which were brought in were shot down by the courts. And this caused a problem as far as, you know, if the judiciary was to interfere with land reform movement, then millions of landless labor would be in difficulty. So the first of the shots was fired. You see, was when the Land Reforms Act was shot down in one of the important decisions of that time, and the yes, this happened in the Patna High Court. One of the Zamindari abolition bills, acts, was struck down, which was called the Bihar Abolition of Zamindari Act 1948, was held as unconstitutional by the Patna High Court. At the same time, the Supreme Court also struck down what is called the West Bengal Land Development Planning Act of 1948 as unconstitutional, because the compensation which the government provided for lands acquired, they felt that the ceiling imposed on the compensation amounts to unconstitutionality of the statute. So this is where the First Amendment Act, the Constitution First Amendment Act of 1951, inserted 31A and 31B into the Constitution to protect all these legislations relating to land reforms. Now, thereafter, after these two decisions came the very famous decision of the Supreme Court in Bela Banerjee and Dwarakadas Srinivas. Again, the entire difficulty was land reforms and the compensation for lands which are acquired. This led to what is called the Fourth Amendment to the Constitution of Act of 1955, where Article 31(2) was inserted that no laws shall be called in question in any court on the ground that the compensation provided by the law is not adequate. This is where the conflict began between on the one side was a government, on the other side was the judiciary. The relentless litigation which went on and on ultimately resulted in one very, very important decision which most of your students would have read, is the decision of Golaknath, which was on a thin majority of 6:5, where in Golaknath they said you cannot amend the fundamental rights. And according to the decision, that a famous judge was Mr. Subbarao. He said the fundamental rights were given a transcendental position in the Constitution and kept beyond the reach of the Parliament. This was one of the beginnings of the difficult periods where there was a conflict between the government and the judiciary. Here was a government trying to implement land reforms, and the judiciary was preventing it from happening. Thereafter, in 2013, two important decisions came about, which brought the whole conflict out into the open. One was the bank nationalization case, and the second was the Privy Purse case. After independence, several kings and rulers were given Privy Purse. The government wanted to abolish it because it was a big drain on the exchequer. And similarly, they wanted to nationalize the banks because they wanted that the banks should be servicing the poorer segments of society and the rural areas of India. Both these actions of the government were struck down in two famous decisions which go by the name of the bank nationalization case, as well as the second one is the Privy Purse case. Once the decision came about, that is, the Privy Purse case was decided on 27th of December 1970. Mrs. Gandhi, Indira Gandhi, the then Prime Minister, dissolved the parliament and ordered an election. Now, this election is very important in judicial history because the Supreme Court relentlessly striking down these laws became a subject matter and an election issue in the ensuing parliamentary Lok Sabha elections. After the elections, Mrs. Gandhi came back with a thumping majority. And then another decision, which again you people have read, comes into being, that is the Keshavananda Bharati, which is called the fundamental rights case, and it evolved a principle that you cannot alter the basic structure of the Constitution. When this decision came about, the government was extremely angry with the situation. The conflict was out in the open, and this is where the first of the decisions of the government, whereby 3 senior judges were superseded and Justice A.N. Ray was made the Chief Justice of India, which is called the supersession of judges. Now, once this situation developed, another series of litigations came about. There were transfer of judges, there were issues of judges not getting confirmations, etc., which came to be called the S.P. Gupta versus Union of India. Now, there are in all 4 Supreme Court decisions on judicial appointments. S.P. Gupta is the first of the decisions which deals with the question whether it is the executive, that is the government, which has the primacy in appointing judges, or is it the judiciary? Because under the Constitution, the words expressed is in consultation with the Chief Justice. Now, when you say a judge of the Supreme Court has to be appointed in consultation with the Chief Justice, does it mean that consultation is only consultation within the definition meaning of the dictionary meaning of the word consultation? Or does it mean something beyond that? Does it mean concurrence? Does it mean if there is a candidate and the Chief Justice feels that he should not be made a judge, will that decision have to be accepted by the government? This was the critical question at that point of time. Now, what happened here is what is called the primacy. Who has the primacy? Is it the government which has the primacy, or is it the the judiciary as embodied in the opinion of the Chief Justice, who has primacy. S.P. Gupta's case gave primacy to the government of the day. I will just read the very telling judgment of Justice Bhagwati, who rationalized, saying that the power of appointment of judges is not entrusted to the Chief Justice of India or the Chief Justice of the High Court, because they do not have any accountability to the people. And if any wrong or improper appointment is made, they are not liable to account to anyone for such appointment. So the rationalization was, here is a government which gets elected. They have to go back to the people every 5 years. And therefore, they will appoint judges. They have that power to appoint judges. And the word consultation in the Constitution does not mean concurrence. It means only consultation. This led to a lot of, I would call it, bad blood between the government, the judiciary, and there was a lot of questions raised as to the independence of the judges being appointed during that period of time. There were several incidents where the question of the government appointments, was it right, wrong, all these things began to get debated. And there was a lot of disgruntlement about the appointments being made. Then came the second judge's case, which is called the Supreme Court Advocates on Record of 1993. This question, who has the primacy, once again was agitated before this court, that is the Supreme Court, in what is called the Scora decision, Scora 1. Now, in this, what the majority held was that when you say consultation with the Chief Justice, it means concurrence. So if a judge has to be appointed to the Supreme Court, there must be concurrence of the Chief Justice. So the primacy in the power of appointments shifted from the executive to the judiciary, which is why in my book I called the second judge's case, that the Scora, made the Supreme Court of India the most powerful court in the world, because it gave the power of appointment also to the Supreme Court. Now, one caveat was made in this judgment. They felt, because there is if you read the debates of the Constituent Assembly, Dr. Ambedkar felt, a Chief Justice is not a embodiment of wisdom in appointments. He is a human being after all. So to give him complete veto on power of appointments was not desirable. That was the express words of Ambedkar. Now, when it came to, in the judgment, how to set this system right, what the judges said is, it is not Chief Justice, it is Chief Justice and two senior most judges. That's how the power shifted from the executive to the Collegium of 3 judges in judicial appointments. Thereafter came the third judge's case, which is called the Special Reference Number 1 of 1998. In this particular decision, what they did was, instead of 3 judges being the Collegium, they made it 5 senior most Supreme Court judges becomes the Collegium. Now, this judgment came in 1998. The first of the Scora judgment, that is the second judges, came in 1993, and a lot of appointments were made. There is one important aspect, this was when a period when the judiciary was extremely independent. If you look at a whole series of judgments, you will find, you see, violation of human rights, the a whole series of decisions on corruption, Colgate scams, etc., came during a period when these two judgments were in operation, where the judges were completely independent because they didn't have to depend upon, as far as appointments are concerned, they didn't have to depend upon the government, and that is why you will find a whole series of decisions which came in during that period, which were thoroughly independent, and yet there has been rumblings. One of the biggest criticism against the collegium system was the talent pool from which judges are selected. It was noticed that either you belong to a judge's family, or you belong to a judge's chamber, or you belong to an elite chamber of lawyers. And therefore, they felt there was a lot of criticism that the talent pool is very, very narrow. As the talent pool is narrow, a lot of competent advocates are not being made judges. This caused a lot of rumbling within and outside the judicial fraternity. There was criticism inside the legal fraternity, outside the legal fraternity, and what is called the first UPA government, that is UPA 2, brought on a legislation whereby they said, this system of collegium system is not an inappropriate system of appointments. We will have a judicial appointments commission. Now, the Judicial Appointments Commission, what they said was, here we will have a Chief Justice and two people who are from outside also will be there. So they sought to replace the collegium system, which is what is called the Judicial Appointments Commission. After that, the government fell and the NDA government came into being, and they brought in again a Judicial Appointments Commission. Now, here the composition of the Judicial Appointments Commission was 1 Chief Justice, 2 senior-most judges of the Supreme Court, and 2 more what they called eminent persons who will be appointed by the government in consultation with the opposition leader. This came to be challenged, and which is what is called as the NJAC verdict, of which I was a part of it. We had challenged the act on several grounds, that it seriously prejudiced the cause of independence of the judiciary, because if you're going to have 2 outside members who will be primarily appointed by the government, then there is a serious cause of concern with regard to the independence of the judiciary. Here, the verdict came. It was a split verdict of 3:2. 4:1. There was only one dissent. 4 judges held that the NJAC was unconstitutional because it impinged on the independence of the judiciary. One dissenting judgment was of Justice Chalameshwar, who said, no, there is no question of there being any impinging on the independence of the judiciary, because the world over, the judiciary has no say in appointing judges. It is the executive which has the say, and there is nothing wrong in 2 eminent persons who have nothing to do with the judiciary being part of a Judicial Appointments Commission. Now, here I would like to point out, see, this Judicial Appointments Commission somehow is a misnomer, because the Judicial Appointments Commission first came into being in the United Kingdom, that is the UK. And there, what they did was, there is a whole history of abuse of appointing of judges. In fact, it was completely government's people who were being appointed as judges, and there was a lot of criticism. There was also a criticism that over 90% of the judges came only from two universities, Oxford and Cambridge. They were not from any other university. So, an elitism had developed in the judicial appointments. And therefore, under the Tony Blair government, they brought in what is called the Constitution Reforms Act of 2005. By virtue of that act, what they did was they constituted a Judicial Appointments Commission. Now, I will point out why it is very important to note the very distinctive features with the Judicial Appointments Commission, which India sought to propose, and what UK had done. In UK, it's a 5-man commission. The commission has a judge of the Supreme Court of UK, a judge of the High Court of UK, a judge of the Court of Appeals, and 2 more judges of lower rungs. What is important is the 6th member of this commission, who will preside over this Judicial Appointments Commission, has got nothing to do with law. It is a lay person. So 5 judges and 1 lay person constitutes the Judicial Appointments Commission in UK. However, here what was done is it was 3 judges and 2 non-judicial members. And the non-judicial members even had a power of veto. So it could be, if the judges wanted a particular candidate, the other 2 could actually virtually veto the wishes of the judges. So there is a fundamental difference in the composition of Judicial Appointments Commission in UK and the Judicial Appointments Commission here in India. One important and significant factor here is that in Judicial Appointments Commission, nobody who has a political relationship, has a relationship with a political party or is in any manner connected with a political party can become member of the commission. And it was also very important that one of the criteria for appointing judges was he is not connected to any political party, because that was the main criticism as far as UK was concerned, that people who are getting appointed are people connected with the political party in power. So this NJC gets struck down here because it is felt that there is a serious infraction of the independence of the judiciary. After this decision came, there has been a lot of criticism about the NJC being struck down and how the judiciary is not reforming itself. Now, the challenges before the judiciary is this. One is to secure independence. Are you appointing people who are independent or have independent opinions against the government? 2, are you appointing judges from a larger talent pool of lawyers, or is it getting confined to only elite chambers? Are the judges being selected? Are they relatives of the judges? Do they belong to the chamber of the judges? Do they belong to elite chambers where only those juniors get the chance? These are the challenges before the judiciary now that the NJC is gone. And this debate you will be finding, all through in the newspapers. Every other day you will come across news items where the Collegium is not in consonance with the Collegium of the High Court, because High Court also has a Collegium. So High Court recommends the names, and the Supreme Court Collegium does not have the confidence in those names. Or sometimes the government opposes the names, sometimes the government is sitting over those names. So there is a lot of debate and churning which is going on in this field. In my opinion, I am constantly asked, was the NJC decision correct? I said, yes, it is correct. Why? because you try to eliminate the government interference in judicial appointments. But does that actually happen or not is again extremely difficult question to answer, because there is again a whole body of criticism that there are lawyers who are fairly independent minded and have political philosophies which may not be in consonance with the government of the day, who are not getting appointed. So this controversy, these problems are continuing, and it will continue, in my opinion, till eternity. And we will always try to find solutions and try to come to some terms so as to see that the best of the people are appointed. So, time and again, we are again faced with the situation. And today also, we are faced with the very same debate which happened way back in the first judge's case, the SP Gupta, second judge's case, the third judge's case, and the NJC judgment. The same problems are still festering. And even now, we are trying to find ways and solutions. Sometimes the solutions are not good enough. Sometimes the solutions are just about managing the situations, and sometimes the solutions are good. Now, this debate, as I said, will continue to go on. But what is very, very important, and I will quote from one eminent member who said something on appointment of judges. And incidentally, the person I'm quoting is Baroness Usha Prasher. She was United Kingdom's first chairman of the Judicial Appointments Commission. She is of Indian origin. And she is a lay person. And this is what she has to say, which will sum up the debate on judicial appointments. Judicial appointment system can and will appoint only the very best candidates. It cannot afford to do less. Our society is not perfect. We face threats from those who claim that it is incorrigibly divided or inherently discriminatory. The composition of the judiciary sends an important signal. When it comes to reassuring communities, there can be few stronger messages than the knowledge that our judges are the best people for the job, drawn from throughout our diverse nation and united in their service to law, justice, and public. Now, this is a very laudable statement, but this will forever remain the beacon light as to who should be appointed as judges. Now, coming to the second aspect, do we need a National Court of Appeal? My viewpoint is there is a huge burden of cases on the high courts. There is a huge burden of cases in the Supreme Court. How do we resolve this? How can we actually resolve this problem? So, having a national appeals court, that is, before it goes to the Supreme Court, you actually have a national body which will hear these appeals and decide it, so that there is some filtration before it goes to the Supreme Court. But my problem is there is a far greater problem even in the High Court level. There are 10, 15, 20 years is roughly the period for which a litigation in High Court also takes to get decided. If a matter is admitted, an appeal is admitted, it will take years and years, be it criminal, be it civil. So this difficulty of the pendency of matters commences not just in the High Court, even from the lower courts. Now, to appoint judges, if you look at the population to judges ratio, India is one of the worst. So, probably the answer lies in having a lot more judges in this country, appointing people of integrity, independence, and competence to these judicial bodies, be it the lowest rung in the judiciary, that is the magistracy and the civil judges. Then comes the district judges and the sessions. Then comes the high courts, and then comes the supreme. I mean, let us assume there is a body is created called the National Appellate Court or whatever. Point is, there is a need for more judges. And the other important aspect is there is a need for very good trained lawyers who will be appropriate candidates for this position. And thirdly, we should have a judicial appointment system which is transparent and will, as Baroness Usha Prasher said, ensure that the very best in the profession are getting appointed. Now, this is a very, very big challenge. UK is the size of Uttar Pradesh. So you can imagine our problems are far, far bigger. Our population is far bigger. But the solution lies that from the very bottom, as I said, I'm very impressed that an audience is sitting here and actually hearing a debate on judicial appointments. So at the very college level, people are interested in how the system is made to work or how it can be bettered, which is a very good sign. And the solution lies in better universities, better education of the law graduates, and I'm an advocate that legal education should be a continuing education. It cannot be confined that I passed an LLB in 1988 and I am allowed to practice without getting myself updated, and which is really not the appropriate thing. If you go to UK, etc., you will find many of the professional bodies require a continuing education, whether it be in the field of medicine, psychiatry, architecture, etc. They require a continuing education. You may be a professional, but still you will have to again re-qualify. So that is something which I believe in, that there is a necessity to re-qualify on these fronts. Thirdly, it is important that the best of the lawyers are appointed. Otherwise, a certain level of cynicism comes into the system, and which is not good. So I have seen, and I'll be quite candid about it, that there have been, and I have seen so many very, very eligible, competent candidates to become judges didn't become, for whatever reasons. And that is a situation which is not good for the country. We need the best of people to come into the judiciary. Now, I find that the kind of salary structure and the perks are good, and the best of people should man the judiciary. And that is the one way to resolve the issue. And of course, the second is there has to be more and more judges, which should reflect the need of the population. So, this is roughly my opinion and my stand on these matters. And therefore, as I said, I think the beacon light is Baroness Usha Prasher's statement that it is to ensure that the very best are appointed. And if the very best are appointed, one of the natural consequences is that the efficiency will be better, there will be less pendency, and that means the judicial system benefiting in large measure on its own competence. So, with that, I would like to conclude my lecture, and I wish to thank all the participants in this lecture to have joined in on a Saturday evening and participate in this. And if there are any questions anybody has, I'm most welcome. It is most welcome and I would like to answer those questions if there are any questions here. Thank you so much, and I thank everybody, and a special thanks to Mr. Devashish Panda for having organized this. And as I said, anybody who has any questions to ask can ask me the questions.
Uh, okay, so sir, thank you for this great speech and uh, input for us on the particular theme of today's webinar. So I would like to call upon Jyoti Prakash Datta to ask questions of the attendees, if at all there are any.
Thank you, Devasis. Sir, it was an enlightening session indeed. We have received some questions from several participants. I would like you to answer all of them one by one. So the first question is, one of the participants has asked that recently in 2018, the appointment of Justice K.M. Joseph was put on hold, and later in that year, the name of Justice Pradeep Nandrajog, the then Chief Justice of Rajasthan High Court, was also put on hold, and he was not elevated to the Supreme Court of India. And recently, also the Chief Justice of Tripura High Court was put on hold, and he was not elevated to the Supreme Court of India. So we have seen these kind of problems over the last few decades. So how can we resolve all these problems?
When Justice, there's a history of Justice K.M. Joseph. See, he struck down a precedence rule in the state where he was the Chief Justice. And there was a lot of delay, and the government was sitting over his file. And in fact, I have published 2 articles on this very aspect. You will get it on Live Law, on the refusal of the government to appoint Justice K.M. Joseph. Ultimately, the Collegium prevailed, and Justice Joseph came up. But as the questionnaire, whoever the gentleman or the lady who has asked, this is not a happy situation. Even today, the Chief Justice of Tripura is an extremely competent candidate to be here before the Supreme Court. And his name, and you would have read in the papers that there are certain Collegium members who are opposing that, no, he has to come here. You cannot keep him there. So it is absolutely, I am entirely in agreement with the members of the Collegium who are demanding that he should be appointed to the Supreme Court. And this is the situation, as I said, does not augur well for the judicial system. You see, to keep somebody because he's written judgments against the government and therefore we will not appoint is not a good sign at all, because it seriously shows that the system is not able to absorb independent minded judges, which goes against the very grain of our constitutional values. So I am absolutely clear that these are the people who should have come here. And they should, and as far as K.M. Joseph is concerned, he should have come in his due time, not much later. And so is the case of Justice Nandrajog, who had to leave, ultimately had retired. And here is Justice Qureshi. Again, his appointment is being stalled. And as I said, it is not a good sign for the judiciary that these incidents are happening not once, it's happening time and time again. And this is something which probably only the Collegium can rectify, and no other way is possible.
Yes, sir. Thank you, sir, for that answer. And the second question is the transfer of judges. We have seen in the latter stage of 1980, Justice Imam Ismail of Tamil Nadu High Court, the Madras High Court, was transferred to Kerala High Court. And recently also Justice V.K. Tahil Ramani of Madras High Court was transferred to a small High Court. So consequently, she had to resign from her post. So what can be done to maintain accountability in the transfer procedure of the judges?
See, the transfer and appointments policy, it is correlated. That is, I don't see, they are not unrelated. They are part of the one composite whole. And it is absolutely necessary that these transfers, which people feel that it is because the judge has been exercising independence, therefore, we are having the person transferred, is not a good sign. And as I said, it does not augur well for the judicial system. And these transfers should be in the rarest of rare cases and on substantiated charges. It cannot be at the whim and fancy of anybody, be it the collegium, be it the government. So that is my view on it. So a transfer, a unwarranted transfer, a unwarranted delay in appointment of judges, an unwarranted refusal to make a person a judge is showing that the system, as I said, is not capable of handling independence, which is not our constitutional value.
Yes, sir. The third question is about women appointment, the appointment of women in the constitutional positions. Some of the participants want to know that we have seven decades into the independence, and we have seen many chief justices of the Supreme Court of India, but we have not seen any female Supreme Court chief justice. So, what is the problem behind it, and whether the women chief justices are not competent enough to hold that position?
See, I am an advocate that there should be women in large numbers in the judiciary. And, somehow here, this question is not being addressed in India. In UK, there is a very leading scholar who has been fighting tooth and nail for incorporation of women into the judicial system. And she starts from the bottom, this problem that, women are not getting appointed. People of color are not getting appointed. This problem has been addressed, and it is sought to be redressed in UK. They're studying, and they are trying to see that the women are there represented in the judiciary. It should not be a token representation. They should get their legitimate right to be on the bench. And also other, there are certain groups of segments of society who are not represented in the judiciary. These are all serious causes of concern, and it requires a serious thought in this process, and it requires an imminent action. It cannot be that you bring in a couple of women here to the Supreme Court and that's it. No, it should be that in the High Court, if women constitute almost 50% of the population, they should be 50% of the judges as well. Because there is no science which says that women are less competent than the men. There is no science which says that. And there are in Indian conditions there may be a difficulty where lawyers will break their their legal careers when there is a family, etc. But this is what the UK judicial system is trying to incorporate. What they are trying to do is, if women are breaking from the profession if they are in the family way or whatever, they are developing systems so that they are brought back into the system after their necessary role as a parent or whatever is over, at least in the initial stages of the child's birth. So the system is trying to absorb the situations which women are faced with, and they are trying to find solutions so that women do not leave the profession, they remain in the profession, and then they get appointed as judges. And they are constantly, reports are submitted to the House of Commons as to how many women are in the benches, starting from the lowest of the judiciary to the high courts, to the appellate court, to the Supreme Court. There is a regular annual report being submitted in the House of Commons. Now, that is something which should happen here also. And if there is a shortfall in women, then the system is to be blamed. It is not the women to be blamed. That is my viewpoint.
That is a great answer, sir. The fourth question that we have received, it is also the last question. Some of the participants want to know that there are several SLP matters in the Supreme Court. It is mostly the SLP matters that are placed before several judges of the Supreme Court of India, and it is the ratio of SLP matters is much higher than any other matter. So should SLP be given this much importance in the Supreme Court?
See, I'll tell you. I have been. I will tell you. See, I believe that that is one positive aspect of the Indian Supreme Court is access to justice is available to everybody. It is very different in the US Supreme Court. The process is cumbersome, the expenses are huge, and there are not much willing takers to put forth cases of ordinary people. So it is a very small section of litigation which comes to the US Supreme Court. Today, we see that almost most of the litigants are able to afford accessing the Supreme Court by way of an SLP. And I'll tell you that there are a large number of cases I've seen in these 3 decades I've practiced. There are a large number of cases where gross injustice has been done. Though two courts have looked into the matter, the trial court and the high court, yet there is injustice and there is a need for redress. And that redress can happen in the absence of a national appellate body. It will have to come to the Supreme Court. Otherwise, an injustice will be allowed to prevail in the court below, which is certainly not a desirable thing. And I will tell you, I'm a big critic of the US Supreme Court because I find it is extremely elitist. It is only a very small percentage of litigation which is coming to the US Supreme Court. So the majority of the people in the country, if they have suffered a bad verdict, in just like our High Court, they call it the Supreme Court of the states. So you'll have a Supreme Court of Illinois, you'll have a Supreme Court of Minnesota, etc. But the point is that those people are not able to access the Supreme Court, which is not a good thing at all. Access to justice cannot be compromised, in my opinion. And even recently, there was a victim of a murder attempt, and the trial court acquitted the accused. And the person was in such bad condition, even today he is an invalid. It goes to the High Court. The High Court again does not seriously look into the records of the matter and confirms the acquittal of the accused. And the person who has been beaten almost to death, he comes to the Supreme Court, and the Supreme Court looks into that and finds, yes, there is injustice done in this matter. So that SLP should be curtailed is something I'm against. That they should pay higher court fee, I'm against, because I believe that it is the people of India who have given us this constitution. It is the people of India which has reposed faith in the judicial institutions. And it is the people who have a right to access these institutions for justice. So that cannot be, by any stretch of imagination, be curtailed.
That's a great point, sir. Our Supreme Court comes down to the grassroots that we cannot see in other courts. That is a great point of our Supreme Court.
For instance, look at this. We had several manual scavenging, which is continuing to this day. But litigations were entertained across the states. And to end manual scavenging, this is something that Mahatma Gandhi thought. You should end this manual scavenging. And even today we are battling that. And Supreme Court is getting involved on behalf of the manual scavenger. Otherwise, I don't see a manual scavenger getting justice in the US Supreme Court ever. I mean, I don't even see his matter getting entertained there. So I believe that the Supreme Court is a Supreme Court of the people of India, and it cannot be confined to very narrow confines of litigation. It has to broaden its base. It has to continue to give the access of justice which has been made available earlier also. That is my stand on it.
Yes, sir. It is considered as the most powerful court of the world, and it is rightly so because it gives us access to each and every person who approaches it with a justified cause of action. So it was an enlightening session. Before concluding this session, with due permission of Honorable Sir, I would like to request Mr. Devasis Kumar Panda, co-founder Team Lex Cognoscenti, to present the vote of thanks to our Honorable guest speaker. Please, Devasis.
So thank you, Jyoti Prakash, for inviting me for the vote of thanks. So thank you so much, sir, for joining us in the today's evening on this particular topic of Collegium system and its history, and what is the current situation here for the appointment in higher judiciary. We are highly elated to have you today, and we are highly grateful, and like we are highly honored to, as you have accepted our proposal for the appearing and giving your intellect and highly knowledgeable speech on this particular topic. So we are highly grateful, sir, and we are also thankful to all the viewers and attendees for this particular webinar. So we are we I from on behalf of Lex Cognoscenti, thank you all. Thank you so much, sir.
Thank you so much. Thank you for inviting me, and thanks to the audience for having been part of this session. Thank you very much.
Thank you, sir. Thank you so much.
Thank you, sir.